All right. Well, good evening, everyone. My name is Angela Riley. I'm the director of the American Indian Studies Center here at UCLA and a professor of law here at the law school. I'm a member of the Citizen Potawatomi Nation of Oklahoma, Bozo. On behalf of the UCLA American Indian Studies Center, I welcome you to the 5th Annual Critical Race Studies Symposium, Race and Sovereignty. I'd like to take a moment at the outset to recognize the indigenous peoples of the land upon which this university was built and to acknowledge all the Indian nations of the Southern California region and beyond. The American Indian Studies Center is proud to be the principal co-sponsor of this year's symposium, which marks an important site of collaboration between the American Indian Studies Center and the Critical Race Studies program here at the law school. As you can see, the symposium agenda is replete with coordinated discussions focusing on bringing to the fore provocative points of convergence between cutting-edge scholars and activists whose work examines the often contested intersection of sovereignty, race, and identity. We look forward to the weekend's activities with great anticipation, and we're so pleased that you could all be here with us to mark this great event. You'll be hearing more about this later, but in conjunction with the symposium, the Center's delighted to present a screening of the film Hearing Radmilla, a documentary about Ms. Radmilla Cody, acclaimed vocalist and former Miss Navajo Nation, and to support a conversation following the film with Ms. Cody and the film's director, Angela Webb, both of whom are joining us tonight. I also want to just take a moment to acknowledge and thank Professor Mashana Goman, who is one of the Associate Director of the American Indian Studies Center and a faculty member here in Women's Studies. Her hard work and vision made the screening and the discussion possible, and we thank her for that. So before we get started tonight, I just want to ask that we all take a collective moment to pause and to look around the room and to really mark this momentous occasion, a rare point in time when we've all managed to come together from all around the world to discuss these issues which have such great academic and personal import to us all. It's fitting, I think, that we are engaging these issues of race and sovereignty here at UCLA and in Southern California, home to numerous Indian nations whose particular histories and contemporary circumstances were and continue to be so profoundly shaped by political and racial contestations over the settlement of the West. Now, in many indigenous cultures, it is customary to start things off in the right way by taking a moment to give thanks and to ensure our hearts and minds are in a good place for the work that we have before us. So with that, I am honored to have with us tonight Rudy Ortega from the Fernandino Tataviam Band of Mission Indians, who will lead us in an opening prayer.
Hello, everyone. With me, I have my cousin Mark Villasenor, and we are from descendants of the San Fernando Valley, from the San Fernando Mission, and we're here to do a small invocation as well as some songs for you. So at this moment, if you can please stand. So I ask you to pray in your own way as we give grace and prayer for today. Dear Creator, we come to you in a humble way. We ask you for all the offerings and blessings that you have given us. We thank you for this wonderful balmy day that you blessed us with such great weather and nature around us. We thank you for all the visitors and people who come together to open their hearts and their minds, Grandfather. I ask you to humble them to open their minds so they can hear the good news that are shared with each other. I ask you to bless the people who travel a great distance to be with us today. I ask you to bless our road and I ask you to bless all the relationships that they have, Grandfather. I ask you to bless everything in the rightful way and everything that's above us, below us, and all around us. So, may be seated.
Thank you very much. We have a small token of our appreciation. 1 second. I give these to you, Mark and Rudy, thanking you very much for being here tonight, and say Chimegwech, deep thanks. Thank you. And with that, I'd like to turn it over to the Director of the Critical Race Studies Program, Saul Sarabia.
Thank you, Angela. I want to start by thanking all of you for being here with us today, and especially for those of you who have traveled many, many miles to be here with us over the next several days. We like to say that we throw a party once a year, and it's a party that means so much to us here at UCLA because, as many of you know, we are the only law school in the United States and anywhere with a critical race studies specialization. I've had the privilege and the honor of serving as the program director for the specialization over the last 5 years, and really come to see this annual signature event both as a moment to connect with a constituency far outside of these four walls that sees itself connected to our broader mission and the larger goal of promoting social justice. It's also an opportunity for the former students who have come through the program to come back for an annual reunion, and to do that in a way that allows them to build on the many friendships and the intellectual projects that they started here as students. More than anything, it's our opportunity to celebrate one another and to celebrate the new paths in this area that we call critical race theory. In that respect, I think it's important to mention that in addition to the co-sponsorship of the American Indian Studies Center here at UCLA has been really an indefatigable partner in this task, and all of you who have planned conferences know what I mean by that. Angela Riley in particular, who's a colleague of ours here at the law school, has been just a terrific partner, and I want to ask you for a round of applause for the American Indian Studies Center. And of course, all of her staff members and all of the volunteers from the center. In addition, one of the things that the faculty and the students of our program were setting out to do by establishing an annual signature event is to really create a platform by which we can examine the new areas of exploration and really the areas that have been underexplored and under-theorized, and even in practice areas where we see gaps that our students and our alums and other people in the CRS community are stepping into to forge a new vocabulary, to create new conceptual bridges, and to really challenge each other over the 3 days around the work that we do and to help sustain us over time. And so for that, I want to also acknowledge all of you who are here to present papers in the concurrent workshops. Without you, this event would not be the same, and we recognize that the work that you're doing is really to push the boundaries of the disciplines that you're in and of our field. So I'd like a round of applause for all those who are here and who've prepared so hard to be here for that work. And of course, I also would like to thank and acknowledge all of the plenary speakers who you will be seeing in this room. This is where we're going to do all of the plenary workshops over the next several days. and to really thank you for taking time out of what we know is a tremendously busy schedule. The only thing we can offer in return is summer, and so we arranged for that, summer in April. It's a little hot, but most people seem to enjoy it, especially if they're coming from very cold places. And we really encourage you to take an opportunity also to experience the larger campus and connect with the beauty of nature here on the campus. For those of us who are blessed to be able to work here, we're glad to see that the sun is peeking out. So I just wanted to take a brief moment to say to you that the annual symposium here is a reunion, it's a celebration, and it's really an expression of the spirit around which we see ourselves doing this important intellectual and practical work on the ground. We see all of you who are here today as partners in that and hope that you will come back for future events. And just know that the next 3 days are what each of us are willing to make of them by engaging each other respectfully and to really encourage ourselves to go beyond what we thought we were prepared to do when we came here. And so with that, I'd like to begin the substantive part of our program by leading us into the opening roundtable. I do want to say, you'll hear from the moderator and the speakers in a second. I want to say something in particular about one of the participants, and that is our colleague here, Addie Rolnick. We launched an inaugural fellowship 2 years ago with the idea that many of our students who have pushed us to expand the framework here at the law school were out doing important work with a particular type of framework that they gained and helped build here in the first 10 years of this program. And the idea of the fellowship was to give people who had been out practicing a few years an opportunity to develop an important academic project that they might not otherwise be able to step into in their practice or in other institutions of higher learning. And so as the inaugural CRS fellow, Addie Rolnick submitted what sounded then and obviously continues to be an ambitious project around bridging civil rights law and Indian law. And, well, I should just say 2 years later we're having this symposium. So I don't know where she is. Addie, thank you so much for all your work. And so I will just say that Addie and the many other alums who you'll meet here today really are our best expression of the mission of the program. And so with that, I want to hand it over to my colleague here, Devon Carbado, who will moderate the first roundtable session. And among other things, he teaches our advanced CRT workshop where we hope we'll bring back several of our future scholars to come back and present their work. Devon.
So the panelists should come forward and take seats.
You guys should sit wherever you want.
Well, good evening again, and welcome. Thank you all very much for coming to the 5th Annual Critical Race Studies Symposium on Race and Sovereignty. As Professor Angela Riley suggested, the project of this symposium, broadly articulated, is to explore the extent to which race and sovereignty intersect. As some of you well know, some of those intersections are decidedly fraught with tension, but some of those intersections are also spaces for opportunity and possibilities. To put all of this another way, to engage the question of race and sovereignty intersectionally is to mark, on the one hand, troubled and troubling domains, legal domains, political domains, social movement domains, in which race and sovereignty exist in a contestatory relation, duking it out as either-or frameworks, political frameworks, legal frameworks, etc. But we can also think about the intersection of race and sovereignty as a space where these two ideas are not functioning oppositionally, but rather co-constitutively. And that sounds, I know, very, very abstract. So part of what this panel will do is to help us think about all of that more concretely. The discussion will be structured loosely around the following few questions. How do we reconcile, as a starting point, the following two dominant narratives? Narrative one, struggles of indigenous communities are typically cast in terms of self-determination, a concept that invites us to think about group rights, differentiation, and sovereignty. Narrative one. Narrative two, struggles of non-native people of color are commonly cast in terms of race and civil rights, concepts that focus our attention on individual rights, assimilation, and citizenship. Can these two narratives be reconciled? Are they even accurate narratives? Can we identify specific contexts within which these narratives are being contested? Can we think about contexts in which they're being naturally produced? Where precisely would we identify as the spaces where race and sovereignty are working collaboratively together? And I mean that both in an historical sense and in a contemporary sense as well. Should we think of race and sovereignty separately? Part of the conversation we're trying to generate here is how we might think about these two concepts working together or not. We might, of course, explore these questions from a number of subject positions and from a number of national contexts. For example, we could consider debates about immigration and the extent to which indigenous people moving from the U.S., from rather Mexico to the U.S., are sometimes framed as immigrants who are here to seek simply inclusion and civil rights. We could also think about problems in South Africa or Australia, where blackness and indigeneity are conceptualized together rather than in a disaggregated way. These are issues that we'll take up throughout the conference, so I urge you to look at the brochures to get a broader sense of the issues we will explore here today. In this particular plenary, though, the idea is to focus specifically on blackness and indigeneity. How do these two identity or concepts overlap and intersect? Our starting point will be a presentation by Professor Kendra Taira-Field, who is an assistant professor of history at UC Riverside. Her work focuses on African American history, on Native American history, and the intersection between the two. She's been awarded numerous fellowships, including the Mellon, Ford, and a fellowship from Dartmouth. In 2009, she was the recipient of the Huggins-Quarles Award from the Organization of American Historians. So she'll take us back in time to think about black migration after the Civil War into Indian Territory. This was decidedly a moment of freedom, but it was also a moment that was deeply connected to and bound up with notions of U.S. expansionism and a particular entailment of that expansionism, which is to say, native loss of land. So how do we think about race and sovereignty in the context when African Americans are moving to freedom on the one hand, and Native Americans are losing their property on the other? Then we'll follow up with Professor Stacy Leeds, who is the Interim Associate Dean for Academic Affairs at Kansas University School of Law and the Director of the Tribal Law and Government Center as well. She's the 2008 recipient of the Fletcher Foundation Fellowship, which modeled after the Guggenheim Awards fellowships to scholars who work advance the spirit of Brown v. Board of Education. She's a former Chief Justice of the Cherokee Nation, Supreme Court, the only woman, I believe, who served in that role, and I understand the youngest person to hold that post, too. She's won numerous teaching awards, and her work focuses broadly on questions of tribal governance. She'll focus the question of race and sovereignty in a specific context here, Cherokee Nation and the Freedmen controversy, which brings the question of race and sovereignty, it seems to me, into sharp relief. Last but certainly not least, we'll have a presentation by our own Professor Addie Rolnick, who is, as Saul Sarabia suggests, the inaugural CRS Fellow and whose ideas helped to make this symposium possible. She earned her JD from UCLA School of Law and went on to represent tribal governments at Sonosky et al., a native rights law firm in Washington, D.C. Her work is concerned with bridging the gap between critical race theory on the one hand and indigenous rights and Indian law on the other. She will focus her attention on the extent to which law specifically is a domain within which race and sovereignty are often framed oppositionally. Her project is to help us think outside of that dichotomy and to think about ways in which we might think about those concepts more co-constitutively. So we'll start off then with Professor Field joining me in welcoming all of the panelists. Each panelist will speak for no more than 10 minutes, and my job is nothing more than to rigorously police that. We'll ask a series of questions and then opening it up to you. So we're looking to end within an hour and then turn over to the second part of the program.
Thank you very much. Can everyone hear me okay? Okay. So today I'm going to share a story drawn from my book project on African American migration from the Deep South to Indian Territory after the Civil War. In my larger project, I investigate African Americans and Native Americans as complex actors on the so-called frontier of the North American continent by paying attention to the presence of Native Americans as slave owners as well as the presence of African Americans as settlers on Indian land. The stories that I uncover contribute in this way to a more complicated and complete history, I hope, of United States empire. And more specific to the themes of this weekend's conference, they highlight tensions between struggles for African American freedom and for Indian sovereignty. I'll talk today briefly about just one of the African American migrants that I trace by the name of Thomas Jefferson Brown. And his experience revealed that at the turn of the 20th century, I should say, the United States was undergoing a seismic shift of self-definition from nation to race, from Indian and American national projects to black and white national projects, and the ultimate, though not necessarily inevitable, futility of attempting to distance oneself from racism in the context of an expanding U.S. empire. Brown's story also highlights, I think, the complex origins of the contemporary Freedmen controversies within the Southeast Indian nations, which I know both of my fellow panelists will address and engage more directly. While the majority of new settlers in post-emancipation Indian Territory were identified as white, many were identified instead as black or as mulatto. Born in Arkansas in the 1850s to an African-American man and an Irish woman, Brown was one such settler and in fact was my own great-great-grandfather. So the larger project is a family history. I trace 4 families and one of them is my father's family. So we have a photo, thanks to that serendipity, of Thomas Jefferson Brown. Brown migrated to the territory in 1870 and married twice to African American descendants of the Creek and Seminole nations. Nearly every one of his 18 children would be allotted 160 acres due to their mother's presence on the Dawes Rolls. This white-looking father, as his grandchildren recalled him, was able to secure over 1,000 acres of land, a school, a church, and a post office, shaping what might have been considered a black settlement in Indian Territory, known as Brownsville. When Jeff married his first wife, Aurelia Bruner, he married into the long, rich history of African-descended members of the Creek Nation who had migrated from Alabama in the early 1830s as part of Indian removal. These are, of course, some of the ancestors of today's freedmen of the Indian nations. Hundreds of men and women known as the Istalesti, the word the Creek people used at the time to refer to black and African-descended people of the Creek Nation, who had lived among the Creeks for centuries, sharing language, food, kinship ties, and much more, and later providing slave labor that helped build the wealth of a number of leading Creek families. Enslaved and free African Creeks also served as cultural brokers, ministers, warriors, interpreters, and negotiators as Creek Indians contended with newcomers, tribal divisions, Indian removal, and the Civil War. But by the end of the 19th century, much had changed for these individuals, who were increasingly referred to as colored or Negro citizens of the Creek Nation. While the Treaty of 1866 had granted freed people of the Creek and other nations citizenship by adoption and promised equal protection, this promise, as we know, held far less weight at the close of the century. Moreover, politicians and reformers alike increasingly viewed the multiracial region as a threat to civilization and Indian progress. And in the 1890s, responding to land-hungry settlers, the federal government ultimately coerced compliance with the General Allotment Act, claiming all collectively held Indian lands and overseeing the Dawes Commission's assignment of individual allotments. One of the most glaring flaws in the deeply problematic allotment process that followed lay in the Dawes Commission's emphasis on blood quantum and the distinction drawn between Creeks and free people of the Creek Nation, who may have made up as much as 1/3 of the Creek population at the time. As Silas Jefferson testified in 1895 when asked if he knew any former slaves who were also descendants of Indians, he said, "I have seen many a one," unquote. Moreover, he noted that in Creek country it was impossible to tell, quote, whether someone was Indian, white, or black, unquote, by appearances. Thus, determining an applicant's degree of Indian blood was a major challenge that turned to controversy when property restrictions and eligibility for benefits were made contingent upon this very percentage. The federal government's intervention in the shape of the Dawes Commission accounted in part for the turn-of-the-century inflation in the value of blood in Indian territory. The focus on full blood status and notions of racial purity grew exponentially at this moment as more and more white and black non-natives or intruders, as they were termed, began to settle the territory, carrying with them deeply racialized experiences of the U.S. South. In 1907, in fact, the state of Oklahoma was officially founded on most of the same terms of racial segregation and disfranchisement that had driven Brown and other African Americans out of the Deep South just years earlier. While blood had long mattered to privileges within the nation, blood identities were now officially sanctioned by the U.S. federal government. Full blood status was now married to the dominant racial categories of an expanding U.S. empire. Within the first 2 years of the 20th century, 10 of Brown's 12 children by Julia Simon, this is his second wife and the niece of his first wife, Aurelia. Within the first 2 years of the 20th century, the children that he had with Julia Simon were allotted the promised 160 acres each due to their maternal enrollment as Creek by blood on the Dawes rolls. The Brownsville allotments, which you can see in the image above, rested exclusively upon Brown's children proving their connection to quote-unquote full blood or racial purity, which they could prove through Julia's mother's family. And this process likely involved not mentioning the possibility of freedmen ancestors, such as those clearly present within Julia's father's family, and also within Brown's first wife's family. So a very meticulous process of claiming certain ancestors and not others, emphasizing instead their full blood lineage. It was often just as difficult, however, to prove one's citizenship by way of freedmen of the Creek Nation. During this same period, Brown's children by Aurelia were working quite hard to prove their own Indian freedman lineage for purposes of allotment. In a letter between Brown and Aurelia's two daughters, passing on her father's instructions, Brown's daughter Cheney desperately urged her sister Rena to register at once in order to ensure Creek land allotments for all family members, painfully illustrating the importance of specificity and consistency in the process of substantiating their birthright. To the Dawes Commission, Cheney wrote the following, and you can see the text above here. I'll read it very quickly, as perhaps it was written. I just want to tell you to go and file right away, and when you go, you must call for Really Bruner, and you must tell them about your grandfather name and uncle's and aunt name that is on the dun roll, and they will ask you about your sister and your brother, and you must tell them, and you must tell the age of them. So you must tell them that I am 28-year-old, and you are about 25 or 26, and Fred is about 21 or 22 years old, and that Sile is about 18 or 19, and you must tell them that Lemmy is 16 or 17, and you must talk one thing. Don't make no mistake in your talking, and you must tell them about my children ages, and that Washington is 7 years old, and tell them that Fredonia was 5 years old last August the 30 day, and you must tell them Benny was 3-year-old last February the 19 day. Papa say that you must try and get $25 this fall to pay for Uncle Para Bruner for his trouble with us, to pray in our prayer right up, and Papa say that you must tell Aaron to go and file right away at once, and don't delay, for in fall they ... So give my love to all, and try to go right away and file at once, and be done with it. So you must do what I tell you, for I just got back on the 27. I will close my short letter from your truly sister, Cheney Wallace. By 1910, a few short years later, African Creeks, still faintly recalled as the Celesti, were divested of their land and socially and politically segregated from Creeks and white settlers alike through a combination of federal allotment policy as well as disparities in the application of these policies, state and local Jim Crow policies, and rampant land and oil speculation. The rights of Creek freed people were increasingly neglected as a massive new wave of African American settlers and intermarriage blurred the boundaries of these populations further. In short, race quickly eclipsed national or non-national status as the leading guarantor of rights and resources in Indian Territory. In response to segregation and mounting discrimination, the emergence of the so-called all-black towns also helped to obscure the once distinct position of Creek freed people in Indian Territory, and thus the Creek origins of communities like Brownsville. In fact, the majority of all-black towns were built upon Creek allotments. The intensifying of a Jim Crow world and the advent of oil speculation intertwined to muddle the possibility and relevance of black Indian identities. As one scholar has noted, the story of the Celesti tells of the nation choosing a future with no place within it for truly multiracial societies. Years later, in the wake of this transformation, Brown felt the need to communicate to his children their exact status in the Creek Nation in terms that nevertheless reflected the growing significance of race and blood in Indian Territory. His son, Charles, passed this on to his own children in the years after Oklahoma's statehood. As his granddaughter recalled, "Papa always told me, you are not a freedman. Others may say they are, but you are not. You are Caesar Simon's great-great-granddaughter and Charity Simon's." Unquote. The statement reveals Charles Brown's and perhaps his father, Thomas Jefferson Brown's, investment in distancing his children from slavery and claiming in its place Creek lineage. In this way, Brown attempted to link his children's fate not to race, but to nation, and in this case, the Creek Nation. By 1904, when a Mississippi freedman moved his family to the plot adjacent to Brown's, and as the all-black towns began to take off, Jim Crow was fully operational, and the emerging opposition instead lay largely between black and white national projects. Soon the experience of land loss in relation to Jim Crow and the rise of oil speculation in early statehood Oklahoma bound together black and black Indian families alike, gradually processing their newly linked fate within the state of Oklahoma. Race and color had so significantly shaped access to resources in the territory that by the second decade of the 20th century, the reverse was also true. Resources could shape perception of one's racial and national origins. As one Creek freedman commented in the early 20th century, quote, "When you get as much money as Johnny, a freedman, you're an Indian and not a Negro," unquote. Before the value of petroleum beneath much of the black and Indian landholdings of Oklahoma was known, and before Oklahoma was 10 years old, the Brown family had vacated their land, which had been leased, mortgaged, and then finally lost to speculators. In the end, as much as this experience of their original experience of land acquisition for settlers like Brown functioned as a national project, a project in which they participated alongside white American settlers staking their claim in the so-called West, the experience of land loss 2 decades later was principally a racialized one. Brownsville is remembered by 20th century descendants and 21st century descendants as Thomas Jefferson Brown's land, not Julius Simon or Aurelia Bruner's land, and as a black settlement, not an Indian or a black Indian one. This is partly because Brown, who was listed as mulatto on the census of the time, appears in most recollections as the patriarch of the family, because it was he who arranged the placement of the allotments adjacent to one another, applied for and received the post office, and set up the schoolhouse and church. But it's also because of much broader changes afoot in Indian Territory in Oklahoma at the turn of the 20th century. Most importantly, the value of blood emerged paramount in turn-of-the-century Indian Territory, beginning with the Dawes Commission's attempt to distinguish between Indians by blood and Creek freedmen when so many residents were in fact connected to both groups. The resulting roles nevertheless codified a hierarchy within which full-blood Indians were entitled to additional land and protected from fraud. This shift was ultimately bolstered, of course, by a Jim Crow state that soon classified Indians as white and African Creeks as black. At the age of 96, Thurman Brown was one descendant who, having grown up in Brownsville and raised by Brown, remembered it the way it actually was. While examining a map of the area, I had unthinkingly suggested to him several years ago, this would have been Grandpa Brown's land. He looked up from the map abruptly and said, "You mean Grandma Brown. Grandpa Brown didn't have no land," unquote. Having witnessed the first century of Oklahoma's statehood, Thurman knew better than most the relationship between land and identity. And in fact, he passed away a year after that, willfully tying this land, as he did, to his black Indian grandmother, Julia Simon Brown. Thurman highlighted the origins of this land as a 19th century Creek allotment, at a time prior to widespread black settlement of the territory and the rise of Jim Crow, when African Americans could still be Creek. Thus, the story of Thomas Jefferson Brown's migration narrates the construction of a new racial order in Indian Territory and ultimately the limits of North American escape. Thank you.
Thank you very much. Professor Leeds, do you have a PowerPoint? No. Thank you.
Okay. Every time you come to a panel like this, there's always some unforeseen similarity or connection that segues you from the previous speaker. And I actually have a Thomas Jefferson in my family as well, Thomas Jefferson Bean, who was one of my relatives and the son of two Trail of Tears survivors, Pleasant and Fannie Bean of what's now Fort Gibson, Oklahoma. And what's interesting about that is that I'm not a direct descendant of Thomas Jefferson Bean. I'm a direct descendant of his sister. But I came across his name in the research that I was doing for a book that I'm writing on the Cherokee Freedmen modern day controversy. But as was just discussed, there's a very rich historical record of these very long drawn-out hearings of who goes on what role and who's entitled to what. And the context that my Thomas Jefferson appears is shortly after the Civil War. Cherokee territory was much like many parts of the South, where there was actual battles going on in homeland areas, and there was disarray where people left for a while and then would originally come back to the places that they were living prior to the war. And in the Cherokee Freedmen scenario, the freedmen that had been dispossessed of their lands during that time period or dispossessed of the places that they were living had about a 6-month window to come back to the territory, and if they didn't come back within that window, then their eligibility for citizenship was no longer there. And so the testimony of my Thomas Jefferson Bean is actually of a slave girl that lived up the road from where my family had lived at the time. And it was a long, drawn-out testimony of that, yes, he knew her, and yes, she lived there beforehand, and whatnot. So hearing this resonated quite a bit with me, and I thank you for that. I'm going to turn the focus toward the present-day controversy within the Cherokee Nation and bring us to the modern ramifications of what was just talked about. For the Cherokee context, much like at least 3 of the other tribes in northeastern Oklahoma at the time, freedmen citizenship came about in 2 different ways. It came about in tribal law context, where each of the tribes that granted citizenship to freedmen after the Civil War did so as a matter of tribal law, but it also came up in the context of federal law through negotiations at the end of the Civil War and treaties. And I think that a lot of times when people hear about the modern day controversy, this shift has been about a treaty-based federal imposition of citizenship, and there's not the discussion oftentimes of the tribal law-based citizenship that either went hand in hand or in some ways, at least in terms of setting this into motion with emancipation, sometimes preceded the Civil War itself. Following the Civil War, the Cherokee Nation, and I'm going to focus just on the Cherokee Nation, but much of what I'm about to say applies to 3 of the other what was called 5 civilized tribes, with the Chickasaw Nation kind of being in their own set of circumstances different from the other tribes. But the Cherokee Nation had a multiracial, multinational citizenship at some point after the Civil War, shortly thereafter, where there were Cherokees that were Cherokees by blood. There were also Cherokees that were adopted and naturalized because they married into the tribe. So those would be adopted whites on multiple roles that you might come across. And then there were 2 distinct separate tribes that came within the Cherokee Nation also by virtue of treaty. And in fact, by virtue of the same treaty with which the freedmen are first mentioned in the Cherokee context. And I think that that's important to the modern discussion, because so much of the modern day controversy in the Cherokee Nation has to do with race as a proxy for ties culturally, where the and I'm going to talk a lot as I progress into the conflict about the hardline approach taken by the Cherokee Nation, but then the equally hardline approach taken by the Freedmen advocates. That somewhere in the middle is I think, the best way to look at this moving forward. But the treaty with which the Freedmen were originally noted as being a party that holds the same rights as Native Cherokees, in that same time frame, the United States government was still trying to dispossess tribes from other lands throughout the United States and again relocate them inside of Oklahoma. And in the treaty with the Cherokee Nation, the tribe agreed to house friendly Indians. Was the moniker. And the friendly Indians in the 1866 treaty with the Cherokee Nation turned out to be the Shawnee and the Delaware that were moved from outside of Indian Territory at that time. And quite frankly, the federal government needed a place to put them because they were dispossessing them from their lands. And so the Cherokee Nation agreed that those tribes could be settled within the Cherokee Nation. And it's still up to much debate what that actually means. But what followed was the Cherokee Nation then also entered into agreements with both the Shawnee and the Delaware about how they would come within the Cherokee Nation. How it has been construed in the modern day is that Delaware and Shawnee people by blood, pursuant to that treaty, have a political existence and a citizenship inside of the Cherokee Nation. And I'm not going to get into the resistance of the Delaware and the Shawnee people to that inclusion too much in this, but it's part of this story of really describing the evolution of what gets us to this present conflict. So during that time frame prior to the allotment process, voting rights were intact for Shawnee, Delaware, adopted white citizens, and Cherokee by blood. And there were a number of Supreme Court cases within the tribe during that time that took up this Freedmen issue. And those cases were never cases about whether they were citizens. It was always cases about which one is a citizen or which group is a citizen. And so it dovetails into the prior conversation. At the time of the allotment process, Cherokee Nation has a unique situation as far as the allotment process goes, because unlike most other tribes within the United States, Cherokee Nation received what's called a fee title, for the lawyers in the room, to the tract of land. And so the Cherokee Nation held their own land in fee. It was never in trust by the United States and supervised by the United States. So when you look at the allotment deeds that went from the Cherokee Nation to individual tribal citizens at the time, the conveyance is Cherokee Nation, signed by the Cherokee chief, to citizens of the Cherokee Nation. And so during this time frame, the allotment process was that everyone who's a citizen is entitled to an allotment. And there's some distinctions about the size of allotments, but freedmen were clearly entitled as citizens at that time, and there's a long history in the land records of freedmen as citizens receiving that same title to the Cherokee corpus of land. After the state of Oklahoma comes into being, the Cherokee Nation goes into what I will just call an underground period, in that for all intents and purposes, the state of Oklahoma thinks that the Cherokee Nation is no longer a political entity. The Cherokee communities continue to function as they would function, but the Cherokee Nation government, as we knew it, really came to almost a standstill, partially because federal law at the time went as far as abolishing the tribal court systems, restricting the meetings of the tribal legislature. And what happened in terms of creating a modern Cherokee Nation is those communities that lie dormant start to really energize in the 1950s and 60s. And that's when the creation of the United Kituwa Band of Cherokee Indians comes on board. And then there's the creation of several community boards that come together to entertain the idea of a newly created constitution. And I'm going to speed up my talk because my time is going quickly. But in 1975, the Cherokee Nation adopts a new modern-day constitution. And in that constitution, there's a citizenship provision that says who is entitled to citizenship in the present-day modern Cherokee Nation. And so it raises the issue of, is the limitation a limitation of citizenship Cherokees by blood, or is it all of the citizens that existed at the time? And the way that it was crafted at the time was that it specifically states that the citizenship would have a direct tie to who were the actual descendants of the Dawes rolls and their lineal descendants. In 2002, I was appointed to the Cherokee Supreme Court, and at that time there were 3 justices sitting on the court. And this issue obviously is not something that just came up new again in 2004 as the media would portray it. There's been multiple lawsuits since 1866 to present. But the lawsuit that was initiated in tribal court was a very narrow one, and it was initiated by an individual named Lucy Allen. And the question was simple. The tribe had passed some legislation that said that you had to have a Indian by blood card in order to apply for registration, and it was a question of constitutionality. Is the legislation that requires one to produce an Indian by blood card unconstitutional or not? And at the time, the court ruled that, yes, you can't have a limitation in legislation that is more narrow than the Constitution itself. And many of you have seen in the media from that point on, there was a election the year later that the Cherokee Nation citizens went to the polls with the question of, do you want to amend the Constitution to change the membership requirements? And by overwhelming majority, the tribal citizens adopted a constitutional amendment that led to the exclusion of the Cherokee Freedmen descendants. I don't think there were any Cherokee Freedmen enrollees, original enrollees, still alive at that time. Since then, and we could talk about this more in the roundtable portion of it, but since then there have been a continued flurry of lawsuits. Most recent activity in the tribal court has been that a class action of freedmen that were excluded during that vote brought the treaty question squarely to the Cherokee courts. And the Cherokee District Court ruled in January of this year that the vote for exclusion was void as a matter of law because it violated the terms of the 1866 treaty, a question on the merits that was never addressed in the first case. There are 2 other federal lawsuits also pending, raising the question of whether there's a federal right to tribal citizenship. And so the appeal from the tribal district court is right now pending in the Cherokee Nation Supreme Court, which is now comprised of 5 justices, and that's where we are. I know that I'm past my time, but there are 3 lawsuits pending at this point, and I'll be happy to discuss some more of those during the question time. Okay.
Thank you very much.
So, thank you, both of you, for being on this panel with me. You can close it for right now. I'm like right in the middle. So I want to use my time, and I'm going to try to stick to it, to talk about the legal context for the debate around the Freedmen issue. And Stacy alluded to the idea that, and I'll talk a little bit more about this at the end, but that the Freedmen advocates sort of took one tactic in making their arguments, and the Cherokee Nation and the people who were the Indian advocates at the time took another position, and that there was sort of a collision between those 2 positions. I want to give some context in legal doctrine, that, and specifically I want to try to make the case to you that legal doctrine, specifically federal Indian law, equal protection jurisprudence, and the tension between them actually produces a dichotomy between anti-racism on one hand and sovereignty on the other, or between race and Indians, and that this is largely responsible for the collision in debates that Stacy alluded to.
So I'll focus on a legal rule called the political classification doctrine, and take a drink of your caffeine because I'm going to turn to law and I'm going to shove a lot into 10 minutes, and I hope we can talk about it after. So the political classification doctrine is a rule that Indian is a political classification rather than a racial classification, and therefore that laws singling out Indians are subject to a lower level of constitutional scrutiny than laws that classify on the basis of race. And the political classification doctrine was articulated in 1974 in a case that I'll talk about called Morton versus Mancari. I just want to say in the beginning that it has at least two important benefits. So in an era when race-conscious remedies are viewed with increasing skepticism, laws that extend benefits to Indians largely survive, and this is because of the political classification doctrine. The doctrine also underscores the political history of tribes as nations that predate the U.S., and this is particularly important in light of the era that Stacy alluded to, in which federal policy was specifically to deny and refuse to recognize the nationhood of Indian tribes. And it also highlights tribes' interest in control over land, which is a separate issue. So I want to focus today on what I see as the costs of that doctrine. And one of those costs is that it often positions race issues and Indian issues, and therefore anti-racism and sovereignty, as oppositional to each other. So I'm going to proceed like this. First, I'll talk about the doctrinal genesis of the political not racial doctrine. Second, I want to elaborate on the contours of the political not racial framework as it exists today, a framework in which Indian is defined as political, and political is in turn articulated as non-racial, and that's the part I'll focus on. And third, I want to lay out some of the costs. So specifically, I'll just talk briefly about how the doctrine does four things. So renders anti-Indian racism invisible. It buries any discussion of race in the context of Indian law. It reinscribes the idea of race, and specifically of blackness, as a natural and static identity. And it drives an artificial wedge between advocacy for Indian rights on the one hand and advocacy against racism on the other. So I'll start with the doctrine, and specifically with Morton versus Mancari. Mancari is a 1974 case in which non-Indians who worked for the Bureau of Indian Affairs challenged a rule that gave preference in hiring and promotion in the BIA to Indians. So a little bit of context. The BIA is the federal agency that oversees almost all Indian affairs. Historically, the BIA directly controlled almost everything in Indian country, law enforcement, courts, natural resources, land leasing, money, I could go on. And historically, the BIA was staffed almost exclusively by whites, and this was still true in 1974. This was a legacy of old federal policies that had explicitly placed white bureaucrats in control of Indian affairs out of a belief that Indians generally were incapable of sophisticated self-government. And it was also a result of structural exclusion, so even when jobs were open to Indians, they tended to lack access to education and training that would equip them to score well on civil service exams, and so they weren't making it into the highest positions. So the Indian preference rule at issue in the Mancari case was an attempt to correct this, and to do so by putting more Indians in senior positions at the BIA. The rule would, of course, work to the detriment of non-Indians who wished to work at the Bureau, but this was seen as a necessary and even a desirable outcome, a step toward the goal of restoring control over Indian affairs to Indian people. So you might be thinking that Mancari looked in many ways like a textbook affirmative action case. And in 1974, the Supreme Court had actually not yet determined what level of constitutional scrutiny was applicable to so-called benign racial classifications like affirmative action. But it was in the process of moving from a moment in which the Equal Protection Clause was, at least at times, interpreted to bar race-based action that because it resulted in the exclusion and subordination of racial minorities. So we'll call this an anti-subordination reading. And to an interpretation, it was moving toward an interpretation of the Equal Protection Clause as barring any consideration of race whatsoever on the theory that race is an irrelevant characteristic and it's demeaning to anyone, not just a subordinated group, to be identified on the basis and treated on the basis of an irrelevant characteristic. And we'll call this a colorblind reading. So whether benign classifications like affirmative action would be treated with the same heightened constitutional scrutiny as the invidious classifications used to disadvantage minorities in the past, it hinged largely on which interpretation, anti-subordination or colorblind, was privileged. And that is a debate that the court in 1974, when Mancari came up, was trying to steer clear of. So given this context, the Mancari court, in addressing this question of Indian preference, could have done several things. At that time, it could have treated the BIA rule as a benign racial classification, so it could have applied a lower level of constitutional scrutiny than it did to racial classifications on the theory that racial classifications that benefit minorities should be treated differently as a matter of law. Or it could have applied strict scrutiny, but it could have held that classifications that benefit Indians could survive strict scrutiny. So even though they were racial, in part, they could survive. And there's a lot of scholars who've done work in this area. But it didn't do any of those things. And what did it do instead? It applied a version of rational basis scrutiny. And rational basis is the lowest level of constitutional scrutiny possible. But it did this based on the argument that the classification Indian was political and not racial. So in order to back up this part of its assertion, that the classification was not racial, the court explained that Indianness, in this usage at least, turned on enrollment in a federally recognized tribe and not on Indian ancestry or Indian racial status. Now, this wasn't entirely true. The court glossed over several complicating factors, so not the least of which is that the Indian legal category was created in a moment of racialization in which hundreds of tribal groups were lumped together into a single category labeled Indian and then treated legally. The Indian preference rules also didn't only apply to tribal members. There's more that can be said about this, but I'll just say that the early rules didn't mention tribal membership, and even today, the tribal enrollment is actually one of 4 categories that can be used to demonstrate eligibility for Indian preference in the BIA. The court in that case seized on a particular version of the rule that required tribal membership and then used that to lend support to its interpretation that it was political and not racial. So the point is this: the court could have characterized Indian as racial but political, or racial plus political, or simply racial, with an understanding that racial categories carry significant social, political, and historical meaning. But instead, the court simply called the classification not racial. And why did it do that? Well, the short answer is to avoid the controversy brewing in the race context over the appropriate standard of review for affirmative action. So, in other words, the context for Mankari and for this doctrine was a moment when in the court when race jurisprudence and Indian law collided, and the court's choice to embrace this oppositional framing by articulating political Indianness as non-racial was a direct response to this context. And the court actually tried hard to limit it to that context, but in the years since the decision, Mankari has been distilled into a simple rule that Indian is a political classification as opposed to a racial one. It's cited a lot for that rule, and it's not often interrogated. The oppositional framing of political versus racial has been lifted out of the circumstances in which it was originally articulated and has come to stand for a more general juxtaposition of the two ideas. And it hardened over time in case law. So, for example, in equal protection jurisprudence, the court slowly started to embrace a more colorblind interpretation of the Equal Protection Clause, in which race is viewed as irrelevant and all racial classifications of any kind must be subject to strict scrutiny. And this was solidified in the Addie Rolnick case in 1995. Meanwhile, the same court that was rejecting all race-based classifications, no matter the purpose in other contexts, continued to apply Mankari to uphold laws classifying on the basis of Indianness. And it gradually expanded the Mankari rule in a series of cases. So in 1976, it used the rule to uphold tax immunity for Indians living on reservations. And so it extends the rule of Mankari from the limited context of employment in the BIA to generally upholding laws that single out Indians on reservation. And in 1977, the court expanded it again, relying on Mankari to uphold the extension of federal criminal jurisdiction over Indians, even if the result is that an Indian would receive a harsher sentence than a non-Indian for the same crime. So this is significant because the court used Mankari here to support a law that disadvantaged Indian people instead of a law designed to benefit them, and it was a law that supported the extension of federal power over Indians as opposed to a law that promoted Indian self-government. So while racial classifications of any kind were being strictly scrutinized, the political not racial doctrine meant that Indian classifications of all kinds were being subjected to only minimal scrutiny. This is helpful in the sense that classifications benefiting Indians can easily survive, but it's harmful in the sense that manifestations of federal power over Indians will likely be upheld, even if they do not benefit Indians. And so I just want to mark that the political not racial rule is solidified in a case in 2000 called Rice versus Cayetano. I'm not going to spend my time talking about it because we have other panelists who are going to do a really good job talking about it in other panels. But I want to mark that case as what I see as kind of the conclusion of it. And Rice is a case about Native Hawaiians in which they're excluded. Ultimately, the court excludes them from the framework of Indian law on the basis that they're partially on the basis that they're not federally recognized. And it tells us something about the doctrinal costs of the framework. So it illustrates the significant consequences of which legal framework, Indian law or race law, is invoked. So once the race framework was invoked in Rice by the court focusing on ancestry as the equivalent of race, the court adopted the colorblind view of race, and what ended up happening is that Native Hawaiians lost in that case. And second, Rice represents the crystallization of the political classification doctrine into a framework in which race, on the one hand, is equivalent to ancestry, and Indianness is equivalent to political recognition. And the two represent opposite or unrelated concepts. So this is the part where I want to show you a diagram that I think helps with this.
Sure, we'll go in 1 minute.
If you can start the slideshow and then I can click through it.
From the current slide.
Okay. Yeah, start it from the current slide. Okay, so real quickly, I think the visual helps. Race in this view is simply a designation signifying ancestry or skin color. It's an irrelevant physical characteristic. It is apolitical, and it is ahistorical, so it has no political, historical, or identity significance. And because of this irrelevance, race should not be used as the basis for distinctions because it harms the dignity of any individual to be judged by an irrelevant characteristic. Indianness, on the other hand, is defined as political, which in turn is defined as non-racial. And then further, political Indianness is largely linked to federal recognition and to tribal membership, so enrollment in a federally recognized tribe. And I'll skip the civic participation piece of it. I'm going to back up there, sorry. So all this to say, this doctrinal framework frames Indianness and race as opposite. And Indian tribal sovereignty, therefore, is framed as a non-racial issue, whereas anti-racism is linked to a story about the journey of African Americans from exclusion to inclusion, and not linked to anything that's happening with Indians. So this doctrinal framework has several concrete consequences, each of which derive from the oppositional framing in which racial is juxtaposed against political and race against Indianness. And I just want to highlight a couple that I think come up in the Freedmen context. The first cost is Indian racial invisibility. So providing a doctrinal incentive to articulate Indianness as non-racial, the political not racial rule obscures racism against Indians. So this is true in a historical sense, in that the narrative of colonization is not framed as a story about racial subordination, so it achieves the delinking of racism from colonization. And the extension of federal plenary power over Indian tribes, therefore, has been articulated in the case law as a simple political matter when it's often overlooked that this doctrine, to a large degree, is predicated on the racist notion that Indians are incapable of governing themselves and the federal government has to have free rein to make decisions on their behalf. It also means that moments where race might be implicated in the Indian law context, such as the Freedmen controversy, the discussion framed in terms of Indian law does not mention race at all, let alone interrogate the questions that Kendra raised about the ways that law has constructed Indian blood on the one hand and black blood on the other. By the federal government and tribes have done this, and by the different meanings that have been attached to each one, and the way that the identities have been policed. Another cost is theoretical. So the political classification doctrine reinscribes race as a static identity for all groups besides Indians. So that is, the argument is that race is imposed on Indians, and that Indian is really a political identity. That also implies then that race is a natural or a voluntary status for other groups. This shows up in the way that the identity of the freedmen as black is rarely problematized. So while race is seen as constructed and imposed for Indians, it's natural and immutable for blacks. And in fact, as Kendra described, this is far from the truth. It's a lot more complicated than that. And the last cost that's most clearly implicated here is what I'll call wedge politics. So because of the different legal frameworks invoked, Indian advocacy appears to be at odds with the advocacy on behalf of other minority groups. So the framework of Indian law focuses on protecting political rights of tribes as governments, and the framework of equal protection focuses us on the individual rights of minorities, often as against governments. And these are they're pitted against each other, and they were in the Freedmen debate. So to link it back explicitly to the Freedmen story, the Congressional Black Caucus, in opposing what the Cherokee Nation was doing, invoked the painful history of African American exclusion and disenfranchisement in the U.S. And they responded to what the Cherokee Nation was doing by trying to stop federal funding to Cherokees, trying to terminate, proposing legislation to terminate Cherokees as a tribe, and holding up legislation that affected all Indian tribes, like the Health Care Improvement Act. And Indian advocates responded to this then by emphasizing the importance of federal support for tribal sovereign rights, including the right to determine the membership, and federal obligations to honor funding obligations based on treaties to Indian tribes. So what's important here is the failure of the Indian advocates to engage the legacy of racial exclusion and the failure of the Congressional Black Caucus to acknowledge the fragility of Indian sovereign rights. The two sides were thus positioned as opposing, and they just spoke past each other. So the broad point is this: the doctrinal interaction between Indian law and race law in the United States and the particular understandings of race and Indianness that they entail, it has set up a framework that this symposium hopes to interrogate, and in which race is oppositional to Indian and anti-racism is oppositional to sovereignty. The framework is neither natural nor unavoidable. That's the point that I want to get across here, and rather it represents only one possible way to understand these two concepts, and it is one that is juridically produced.
Great, thank you very much. All right, so we'll thank the panelists for those very provocative comments. I'll just ask a question of each very quickly and then leave some space for you all to engage them as well. If we start with Professor Field, I wonder if you could say something more about how about the middle ground, which you didn't get to articulate in the paper. So you mentioned the pro-Cherokee position, the pro-Freedmen position. What exactly is the middle ground and how can it be occupied? For Professor Field, I'm hoping that you might say something more about how conceptions of race within Indian country shifted as a result of people moving into that terrain, carrying their racial ideology with them. How can we think about Indian agency within that context vis-a-vis definitions of race? Is it an externally imposed dynamic? Were there conceptions of race that were emerging apart from that? How might we think about that a little bit more? And finally, Professor Rolnick, if you could say a little bit more about what it would mean in the context of a case like Morton v. Mancari for the court to take race and political identity together. Wouldn't race automatically corrupt the political identity of Indian status in a way that means that exactly what happened in Morton v. Mancari, which is a moment in which you have an affirmative action program being declared constitutional, that moment would not be possible if race and political identity are conceptualized intersectionally. How would you respond to that argument? Sure.
Okay. Well, 10 minutes was almost laughable to scratch the surface of the complexity of that. So the piece that I want to impart...
And just, I should be clear, I'm sorry, just one more thing. What is laughable now is that I'm giving you each no more than 2 minutes to respond. That's laughable.
That's laughable. Okay. On the one hand, you have the Cherokee Nation, who has at least spent a lot of time in the last 300 years making the case that they're an international sovereign that reckons with the rest of the world in terms of sovereignty, self-determination, but taking the viewpoint that sovereignty gives you the right to do whatever you want without any external lens looking down. On the flip side, then you have the Freedmen advocates immediately running to Congress, asking Congress to step in and terminate the existence of the Cherokee Nation as a political entity, which is asking for plenary power, this notion of federal intervention over everything Indian to come in and interfere with the government. And I think that the midpoint from the Freedmen advocacy that I would have liked to seen, and as somebody who was sympathetic to the point of view as far as inclusion and continued inclusion, is don't run to Congress and ask for the termination of tribal existence in the nation you want to be a part of. Go to the international community and say, shame on you, Cherokee Nation. Sovereigns don't make decisions like that to marginalize people. But running to Congress and asking for a paternal remedy to that, I think, was as disheartening as the Cherokee Nation's position of, I am sovereign and you can never touch me. Leave it at that.
Thank you very much. Professor Field.
Sure. Well, racial conceptions of race or racial ideology within, for instance, the Cherokee and the Creek Nations, most historians, have suggested as early as the very early 1800s, you have kind of hardening racial ideology within the nations, and that's furthered, especially by the kind of gradual establishment of racial slavery in the Southeast, as well as by, soon enough, by the experience of Indian removal. So Ty Miles has written historian Ty Miles has written really quite beautifully about what the displacement from ancestral homelands in the Southeast United States did to relationships between Cherokee and African Cherokees, or between Creeks and African Creeks. That the separation literally from the land that they had shared for centuries made possible a kind of further dissolution of these bonds. And then the Civil War, of course, the escalating of sectional tensions as well as the Civil War further kind of eroded these relations and hardened racial ideology within these nations, within a segment of the nations. And then ultimately the allotment era, the kind of increasing vulnerability of Indian sovereignty for the Creek and the Cherokee in particular, I would say, kind of was the final point in that kind of hardened racial ideology.
Thank you.
Okay, 2 minutes. So what would it mean to take race and political identity seriously? And specifically, wouldn't race corrupt a case like Mancari? Wouldn't it mean that all of Indian law collapses? So I'll say, as critical as I am of the Mancari decision, I don't think it should be overturned. And it's not just because it's useful. The Mancari decision actually, if you read it carefully, recognizes Indianness as both a racial and a political category, or a racial category that also has political content. There's particular language about political, not racial, that's sort of been lifted as the language that comes out of that case, but the case is actually much more nuanced than that. And I am not arguing, like the court I don't think was reading it in the case, for replacing a political analysis of Indianness with a racial analysis, but rather to link the idea of racial to the idea of political. And in a narrow sense, so the court could have achieved this in the Mancari case in a very narrow sense by just acknowledging the sort of racial but political version, which is acknowledging that Indian is a racial category, but given the historical circumstances of colonization of Indian and treaties and all that went on in the history of federal tribal relations, this kind of a classification was necessary to undo some of that historical damage. And what's interesting about Mancari is it does lean on that history. But the more difficult and broader reading of it, which I think would trouble the doctrine of the court in a bigger way, is that if we take seriously the link between racial and political, and I'll just kind of open it up in this way, why not apply that to other groups? So why not apply it in the other direction? Why not just bring race into the political analysis? Why not then link political to racial in the context of other minorities, which would sort of open the door to a consideration of history that is absent from race jurisprudence today, and to a consideration of political and group rights remedies that is absent today.
Great, thank you very much. So questions up from the floor. Yeah.
Can I make more than a question, or is it just one straight question?
If you have a comment, as long as it's brief, that's perfectly fine.
Okay. Firstly, thanks very much for your fantastic stuff, all three of you, the way you work together. And I intend to take your wonderful complexities and to simplify them dramatically. Because I think that one thing that does help in discussing these kinds of questions is to remind ourselves of the fundamental economic relationship into which different racialized communities were initially co-opted by European colonizers, which in the case of indigenous people has to do with eliminating them from the land that the colonizers want. In the case of enslaved people, is rather than being an inclusive sort of policy of assimilation to get rid of them, is an exclusive one to maximize the number of slaves that people can earn and all the rest of it. So you get very different racial regimes imposed upon the two peoples. They have sought to impose very different racial regimes, or obviously don't always succeed. Crudely as it is, it nonetheless largely holds that the one-drop rule is the sort of high point of this, that blackness is maximally insensitive to dilution. Okay? Paradoxically, black blood is incredibly strong, whereas Indian blood is antithetically the opposite. Indian blood is maximally vulnerable. So The racial regime that encompasses them both has the effect of taking away Indianness wherever possible. Therefore, with great respect, Eddie, I'm not really disputing you, but I think that to say that Indians are made non-racial is actually to say that's how they've been racialized, as their status is vulnerable to being dissolved into whiteness. The point, therefore, that I'm trying to make, I think that we really should be bearing in mind the whole time, is that these antithetical relationships subsume the same end, which is the production of the Euro-American social formation. Thus, when you have conflicts, apparent conflicts, like a conflict between race and sovereignty over civil rights, where that which African Americans were seeking, which was involvement, equal treatment, participation with white people, was precisely what Native Americans were politically premised upon opposing, because that means you lose your sovereignty, it becomes a numbers game, you get overwhelmed. Now, so far as solidarities are concerned, the two should be recognized as antithetical but complementary contributions to the one colonial social formation which is Euro-American society. There's no ultimate conflict at all, but those differences have to be recognized.
Take another question there.
Yes, I'd like to ask Addie whether she would be open to reconsidering the judgment in the Rice versus Cayetano case, because you said that's a loss on Native Hawaiians. That's, to me, a very troubling conclusion, because the people who have been pushing the Akaka bill in Hawaii, have been saying precisely that quick sign on to become a recognized Indian-like tribe, otherwise we're going to lose everything about Rice versus Cayetano. And I believe that Rice versus Cayetano does not do that at all. Because, first of all, if the Native Hawaiians are a political entity of some sort, then they ought to be dealing with the state or with the federal government and not with the state. And OHA was a creation of the state of Hawaii, not of the federal government. So the minute the state gets involved in dealing with a group like that, right, since it is not allowed under the U.S. Constitution to engage in international type relations, then it is dealing, at least under the present system that we have, with the race. So therefore, that election was, in fact, in that logic, race-based. Moreover, it was an election. It was not a program for schools or for anything else. It was an election. And the court declined specifically to rule on the 14th Amendment. It was invited to, but it refused. It ruled strictly on the 13th Amendment. 15th. I mean, exactly. But it declined to rule on the 14th Amendment. So our view, rather, is that we must not allow the colonialists to sort of say, quick, your only choice, you Native Hawaiians, because of Rice versus Cayetano, is to agree to become an Indian tribe. Do you see what I'm saying?
Yes.
So I think it's very important to see how that has been manipulated by people who really do not want to hear anything about the Hawaiian independence, drumming it up as a major loss. Okay, so I'd just like to see whether you're open to that.
Yes. So I am. So part of the reason that I punt a little bit on talking about Rice in this is that it's a very complicated case, and that there are other people who are going to do a better job of talking about it here. I do want to say something about what I mean when I say that it was a loss. And I mean a loss in the sense that because of the juxtaposition between Indian law and race law and between political and racial, indigeneity doesn't really have legal significance in American law. And so I mean that in the sense that an indigenous group that doesn't fit into the box of politically recognized tribe, which Native Hawaiians were a group like that in the case and still are, there's a lot more ground to sort of attack the rights of those groups because the definition of indigenous is being, I think, slowly collapsed by the court into just being equivalent to a federally recognized tribes. And Native Hawaiians aren't the only example of groups that sort of end up being caught between this. And a loss in the sense that it's not just that the only choice is race, but the only choice is race, and the doctrine around race is not helpful for racial minorities. So if you get, to simplify a lot, if you get left in the race box by the court, you don't really, the chances of sort of the remedy being awarded are slimmer and slimmer, and this kind of gets into a whole discussion about race jurisprudence that is bigger than this. And so that's not to say that indigeneity has no legal significance anywhere, but that, so this is why it's complicated. So there, to the extent that Native Hawaiians go outside of U.S. law, or that there are ways to find within U.S. law a way to articulate Native Hawaiian rights, outside of that dichotomy, there's still room for that. But I think the point is that the larger dichotomy between them starts to render these groups that are in the middle sort of increasingly in a corner. And that's the sort of the limited sense of what I mean by loss.
Great, Professor Field and Lead. Any concluding remarks? Unfortunately, we are running out of time, so I just want to give a quick opportunity for you both to say last words, and then we have to close. No? Great, then we will adjourn.
I'd like to thank our moderator and our opening roundtable for kicking off the symposium with such invigorating discussion. We are going to start the film in 5 minutes. In those 5 minutes, if you need a restroom, you go this way. There are cold beverages, because I know it's getting hot in here, and desserts right in front of here. But we will start the film in 5 minutes. Thank you.